to recognize that council members, EDA board members, planning commission members, other members of different boards and commissions are required to have training on FOIA within 2 months after their appointment. There's no penalty if you don't, but it's one of those things that you ought to do. As well as council members need to have a training after an election and every 2 years thereafter. So basically, if you have a training after each election, then you're going to be covered. So I'm here to do that training. The Freedom of Information Act is the principal statute in Virginia that covers open records and open meetings. And for you, as the town council, I'm going to focus more on the open meetings, although it's still important for you to understand what goes on with the records. I want you to understand that when I do this same training with Ms. Crozier, I focus a lot more on the records because she spends a lot more time managing records. I'm going to focus more on meetings with you, but everybody really needs to understand both, at least to some extent. I'm also going to touch a little bit here and there on what's called the Public Records Act, which is a statute that governs how and when you have to keep documents and when you have to destroy documents. And we can go through that in great detail if you want to, but I'm not going to do that tonight. The other two things that you have to worry about are the First Amendment. I'm going to touch on the First Amendment, people's right to speak and when and how. I'm also going to touch on the Americans with Disabilities Act because that can also touch on things related to public meetings. So I'm going to start off with the records so that we can get that sort of out of the way first. A public record is anything in a tangible medium that relates to the transaction of public business. So when I say in a tangible medium, I mean something written down on paper, obviously. It can be an electronic document, so it can be an email, it can be a Word document, an Excel spreadsheet, a PDF. It includes drafts. It could include text messages, although text messages can oftentimes be extremely difficult and therefore expensive to extract, so oftentimes people are willing to forgo that. But all of these things are at least potentially FOIAble documents. And the term transaction of public business is only partially defined in Virginia law. So it's a common sense standard. If you want to talk about, talking about the tax rate is transaction of public business, at least is transaction of public business. Even if you don't do anything, talking about it is transaction of public business. Talking about that wonderful sermon that the pastor at your church gave last Sunday, not transaction of public business. If the five of you happen to run into each other at Jack Mason's Tavern and are chatting about that wonderful sermon and you don't talk about town business, you are not holding a meeting. Of course, by the same token, if you do start talking about town business, you are, and that's a problem. So anyway, that also tells you something about, and this is an important thing that I want you to keep in mind. Do they have town email addresses? Yeah. Keep the two separate. Use your town email address for all of your work as a counselor. Use your personal email address for all your personal work. Now, that's not to say that every once in a while your spouse isn't going to send you an email at your town email address saying pick up some milk and a loaf of bread, and that email is not going to be a transaction of public business. It's not subject to FOIA. However, if you get business emails at your personal email address, that is potentially FOIAble, and there was actually a case about this last year. And what you actually have to do as a locality is you have to ask the person who got the email at their personal email address to please turn it over, and you can't actually make them. However, it's one of those things where as a leader of the community, we're going to ask that of you if we're in that situation. So be careful as to how you use your the different options that you have. Now, a FOIA request is any time that someone asks a government official for a public record. They don't have to use the word FOIA. They don't have to put it in writing. It's oftentimes better if you can get them to put it in writing. And I have the example, and this happened to me, it was almost 15 years ago now, but this was in a county in central Virginia, and the clerk to the Board of Supervisors, their equivalent of Kyla, took a FOIA request and took it by telephone and wrote it down. They didn't get it exactly right. So they went and they searched, and they got 250 pages of documents that they thought this person wanted. And then they sent the 250 pages of documents to this person, along with a bill for $200 for having searched for those documents because they were awfully hard to find. This person was in fact only asking for 2 documents, which were a total of 12 pages long, and they were not thrilled about the bill. So oftentimes, if you can have a good communication with that person and get them to put in writing exactly what they want, it's going to eliminate confusion, and it's going to eliminate recriminations later. In that particular situation, 2 of the 7 supervisors wound up involved in trying to mediate between people. It was a disaster. If we had just had it in writing, never would have had that problem.
Mike, can I ask you a question on that very specific topic? And this happened here about a month ago. So you do get it in writing, and once you read the written request,
yes,
you know that it is going to be a much, much bigger document and much more involved than this person is probably actually interested in. Are we responsible to go back to that person and ask for them to clarify their request, or do we just honor their request as written?
I will circle back to that. There is a way of addressing that situation, and it's actually, for good or bad, it's written out in the statute, so you kind of got to follow the steps, but there are steps to address exactly that situation. One thing I do want to say is you can always request somebody, you can not just request, you can demand them to give you their name and their contact information and their home address. This is because only Virginians are eligible, only Virginians, media outlets with significant circulation or broadcast presence in the Commonwealth of Virginia have the right to take advantage of the Freedom of Information Act. So, and this was recently upheld by the U.S. Supreme Court. That's not to, so if somebody who's a data aggregator out in Oregon asks us a FOIA request, we may very well tell them to go fly a kite. However, that doesn't mean that you don't want to use a little bit of common sense. If, say, the Timmons Group asks us for some information about with engineering firm, let's say that somebody out of their Greensboro office asks us for some documents, which actually happens, right? Business considering locating here in Clifton Forge, they want some documents about the background, the environmental background of the site. We could tell them no, because they're not from Virginia. On the other hand, Timmons also has an office in Richmond, which means that somebody from their Richmond office is going to send you an email 10 minutes later, and they're going to be annoyed with you. So sometimes you want to use a little bit of common sense on these things. Next question is, do you have to respond to a Freedom of Information Act request? And the answer is yes. Even if you don't have anything, or even if everything you have is exempt from FOIA, you still have to give a response. The basic response time period is 5 business days. So, person sends you a response, the next day is day 1, 2, 3, 4, 5. Okay? Now, oftentimes when you get a FOIA request, it's going to be something you wouldn't bother charging for. Oh, can I have a copy of the town's audit from last year? Well, guess what? That's on the town website. We're just going to send you a link, right? Very easy. Nobody's going to take much time for that. But if, as in Chuck's example, you have a situation where somebody makes a request and you realize there's going to be a charge for this. In fact, it may be a substantial charge. You need to tell them, hey, there may be a charge for this. Are you sure you want me to move forward? At that point, that 5-day period stops until they tell you yes or no. If they say, hey, I'd like an estimate before I give you the go, then you go and you make them an estimate, but the time that you spend estimating, again, does not count against that 5-day period because you haven't gotten the go from them yet. Beyond that initial 5 business day period, if the response is large or it's difficult to put together or you have something else going on, for instance, if you want something from our finance department right now, Ms. Biggs is working real hard on a budget. So she might need 7 extra days to respond to a FOIA request just because of what else is going on that's a demand on her. Similarly with our Public Works Department. If we happen to have a water main break and it's going to take them 3 days to fix it, they're just going to ask for another 7 because that 5 business days isn't going to do it for them. So you send that letter out and then you get another 7 business days to get the response. Now, if you still can't get the response completed within that 12 business day period, you typically are going to reach an agreement with a requester. So I give the example of a situation where everybody was actually very kind and reasonable about it. Was a situation I was part of a team of lawyers representing the City of Falls Church. The City of Falls Church was fighting over water system service territory in Fairfax County with the Fairfax County Water Authority. We were getting ready to sue each other. There was no question. We were certain. And so Fairfax County Water Authority sent the city a massive FOIA request, which ultimately produced 80,000 pages. We sent them a FOIA request, which ultimately produced 110,000. We were extremely relaxed about timelines. I also, on the other hand, had a situation down in Botetourt County 8 years ago, where somebody came in and they asked for, it wound up being 12,000 emails that we produced, and they refused to give us extra time. And so I went and filed a petition in court to get extra time, and the judge had absolutely no difficulty giving us an extra 3 weeks to respond. So,
Mike,
yes.
if, just say Jenny comes to me in the street and says, I got Freedom of Information Act, I want to know your text of December 10th or whatever.
Mm-hmm.
Does she come to, do we have to give that, or does she have to come to
Well,
town hall?
I'm going to get to more in the details of that. She can come to you. However, the very first thing that you're going to want to do is get that off your desk and onto the desk of the Freedom of Information compliance officer. So I'm going to go over to that and just cover that and then circle back. So the citizen asks you for that document. What are you going to do first? Obviously, if it's Jenny, you're probably going to say, Jenny, can you just put that into an email and send it to Kyla? And that's what's actually going to happen. Sometimes people aren't going to be willing to do that. Sometimes you're going to get it and you won't be able to talk to them directly or whatever else. You, as a town councilor, will get it off of your desk. You want to say, put it into an email. This is what it is. Kyla, this is what it is that I got a FOIA request about. This is who it's from. Can you please take care of this? What she's going to do is she's going to calendar that. So make sure that the 5 business days are figured out. If it's going to be a charge, or if it's unclear what the person wants, she's going to call them up and chat with them and figure that out. Hopefully they're nice to her, because they should be. She's then going to act as the liaison with whatever town staff member happens to actually have the documents in order to pull those together. If there's any funny issues of legal interpretation, she might give me a call. And she's finally going to send out the response to the requester. So the short answer is, yes, somebody can ask you a FOIA request, but the very first thing you want to do as a town councilor is to get it off of your desk and onto Kyle's and Chuck's.
Can I ask a question on that? About the FOIA, so if you're doing it by email, would there still be a charge? Because you were talking about printing things off. And if you're emailing, there is no print fee. It's straight through the internet.
Well, I'm actually going to touch on that right here. I know it may surprise everyone to find out that the town does not actually have someone sitting around waiting to respond to FOIA requests. So what the General Assembly has recognized is that the town gets to charge for its actual cost of responding to a FOIA request. So if the estimated cost is going to be over $200, you can ask for a deposit up front before we start working on it. And as far as responding to it, printing charges for, if you ask for it on a memory stick, the $10 that it would be for that memory stick or whatever it would be, maybe with inflation it's up to 20 now. I haven't bought a memory stick in a couple years. However much it is that it's going to cost, you can charge that to them. Now, the difficult part, particularly in a situation where where somebody is asking for a lot of old documents, or a person is looking for a lot of documents that are difficult to find or that are difficult to pull out, is that you can charge that person for the time spent, and you charge them at the wage of that time, at the wage of the lowest paid person with your locality who could reasonably do that work. It appears as though there's going to be a bill that passes I believe it already has passed the General Assembly. It's going to go to the governor's desk. That's going to say that charge cannot be above the median wage of all of the employees of the locality. That looks like what it's going to be, but that could still be a fairly hefty sum of money if it, say, takes 10 hours to pull together those documents. And finally, if someone hasn't paid for a previous FOIA request for at least 30 days, you can thereafter refuse all future FOIA requests from them until they pay.
I have a question.
Yes, sir.
What if someone on fixed income needs that FOIA and they can't afford to pay that amount of money? That doesn't seem fair. You know what I'm saying?
And we could have, I know that, I don't believe that currently the town has a policy of waiving FOIA requests, of waiving fees for FOIA requests. But if you wanted to have a policy of waiving those for people who could show hardship, then you could certainly have one. I know. Yeah, I'm not going to make any further comment.
It's like the economy now. It seems like the rich get richer, the poor get poorer, and sooner or later you can. Usually me, I can pretty much pay whatever it costs. Where I have some family members who can't even come close to paying for a photo, So it's just so.
In my experience,
way of doing things, I think.
in my experience, it doesn't come up that often, if only because people who are, pardon me for stereotyping a little bit here, but people who are poor are oftentimes working too hard to be dreaming up things to make FOIA requests about.
No.
But yeah. There are some documents that are really sensitive that are in the town's possession. I might have written a legal memorandum to Chuck or to council. You might have an appraisal of a property that the town is considering buying or selling. You might have things like that where you really need to keep it confidential. And there are some exemptions under FOIA for those documents. Now, before I get into that, I want you to understand that FOIA is liberally construed in favor of disclosure. So if you're going to withhold a document, you need to put your finger right on exactly what it is, the reason why you're withholding it. Second thing here is, If part of a document is subject to exclusion but some not, you do have to X out the part that's exempt and produce the rest. Sometimes you reach an agreement with somebody and say, look, it's going to take me a bunch of time to do that. I'm going to ask you to pay me for that time. How about I just withhold this document or just let you read it rather than make you a copy? There's different ways that you can work that out with somebody, assuming that you're acting on a neighborly basis. Some of the most commonly used record exclusions are personnel information. The person themselves gets to review that personnel information. I wanted to note that there was a recent case that went up and down. It's gone up to the Supreme Court of Virginia now twice. It's a series of cases between the town of South Hill and a fellow named Richard Hawkins. And it has actually narrowed the personnel exemption. It actually had to do with complaints and personnel reviews of the town manager. And what the court held, when you get right down into the details of it, it held that a citizen petition for removal of the town manager was FOIA-able. However, the personnel reviews by town council of his performance was exempt from FOIA because that was a personnel record. It got really complicated and nobody's sure actually exactly what the court's opinion means. Work product or memoranda of legal counsel, communications with legal counsel in general are usually going to be exempt. Proprietary information or trade secrets provided by an economic development prospect. Chuck's working papers, it's assumed he's going to have a little notebook in which he keeps his notes about things that you guys tell him and his notes on how to go about doing them, and that consequently he probably doesn't want everybody in public to know what all of those notes are. Memoranda prepared only for use in closed session, and of course confidential information related to a public contract. There are a bunch of others. I want to say there's 120 or so exemptions under FOIA, but there's about 10 that you're going to come across in 20 years on council because the vast majority of them just never come up. We already talked about the role of the FOIA officer. Now what we need to have on our website, the identities of the FOIA officers, statement of the rights of FOIA requesters. We need to post the dates, times, and places of public meetings. We need to make sure that your agenda packages are available to the public at the same time that they're made available to you. The easy way to do that is to put them up on the website. And finally, the minutes of meetings need to be posted on the website within 7 days after their approval by the council. Let's turn to the actually somewhat more interesting part. I'm sorry. Public meetings. So anytime 3 or more members of council meet together, you're at least potentially having a meeting. Yes, sir?
Can I ask you one more question about documentation?
Oh, y'all can ask me as many questions as you want.
Is it correct that if the information that they have requested does not exist, we're not obligated to fabricate that or make that to give that?
That's exactly right. It's important to distinguish a question from a FOIA request. A question is what you think about something. What is the town council planning to do about X? What policy would you support with respect to Y? Those things are, those are questions. Those are not FOIA requests. FOIA requests are requests for documents or for documents that show particular specified pieces of information. You don't have to create a new document. So there's never a requirement to create a new document, although if someone is asking for a report that can be easily extracted from a database, you do have to extract it from the database. But you don't have to use a report or a file format that's not something that the town would normally use. So if somebody asks for what's the utility usage for the town or what are all the utility bills for last month? They're part of that. There's actually a FOIA exemption for parts of that, but the part of that that's just the bill itself, the amount of money, that is subject to FOIA. and you can run that as a report out of the database. And so you might have to produce that. So in order to hold any kind of meeting, and as I said, a meeting is a place where you're transacting public business, where there are 3 or more of you. You got to post it. In order to do that, you got to post on the town website that a meeting's going to occur. You got to post it in another prominent location, and you got to post it in the office of the clerk for the council. You need to give notice of emergency, special, and continued meetings. And obviously, those don't necessarily have to be with the same length of time. For a regular meeting, it's 3 business days notice. It can be shorter for emergency, special, or continued meetings, provided that you give it as early as you can and you give notice to the press at the same time that you give it to the public bodies. You do have to take minutes of all bodies that have the ability to make decisions. Advisory commissions, you don't have to take minutes, but for council, planning commission, EDA board, they have to have minutes. Finally, you have to have it in an ADA accessible space. Town of Bedford, their town hall, their meeting room is on the 2nd floor. There is 1 elevator in the building, and the elevator was out of service for 2 months, and they actually had to go meet in the county board of supervisors meeting room in order to make sure that it was handicapped accessible. You can hold electronic meetings or partially electronic meetings, provided that you have a policy. A physical quorum is assembled at one location, so at least 3 of you are here. Whatever member wants to call in has advised the mayor of the situation. I say chair, but that could be the chair of the EDA board or the chair of the planning commission. And one of the following situations applies. Either they can't attend because of a medical problem that they have or that someone in their family has that they need to care for them. You're not going to have any problem with being 60 miles away from the meeting location, most likely. Or that you're unable to attend due to a personal matter, but there's a cap on the number of times you can do that. And then we have to have a vote to allow you to call in, although if the other council members don't want to allow it, they have to state on the record why it is that you didn't comply with the statute, so that you can challenge it down the road if you wanted to. And it has to be put into the minutes. Note that there are special notices for special meetings. Rezonings, you got to give notice for 2 weeks in a newspaper. Adoption and amendment of ordinances, there are some posting requirements. For the budget, you're going to hear about some of the posting requirements and advertising requirements for budgets. I think perhaps, if not tonight, you're going to hear about them very soon. And if you're going to sell a bond, you need to give public notice before you can do that. And if you don't do the notice right, it never happened. So notice is particularly important. The next question is, who can talk at a public meeting? Obviously, council members, you have the right to talk. There are Robert's Rules of Order, there are rules of procedure and decorum, but generally you can say whatever you want and you can say it at any time because you are councilors. The rest of us only get to talk under rules, at times when we are told, at times when we are permitted to do so, for the time period we are allowed to do so, and on the topics which we are allowed to talk about. So, in general, for instance, if you have during our public comment period, Judge Moon, the federal judge down in Lynchburg, said he once described the Lynchburg, in a case where somebody was suing Lynchburg, he called the Lynchburg public comment period open mic night. As long as you can, this was a federal judge in a published opinion, and he said that as long as you don't talk for more than 3 minutes, he's like, you can say whatever you want during public comment. Now, if you're having a public hearing on a rezoning or you're having a public hearing on a budget, people need to talk about what you're there to talk about. If you're there to talk about a rezoning of a piece of property across the street right here, and somebody goes off about how we ought to annex some land from Allegheny County at the other end of town, you can, no, hold on. That's not what we're here for. It's not germane. You can cut that off. Generally speaking, however, unless somebody is getting belligerent or obscene to a degree that you just can't deal with, let them talk. It is always going to be far easier to listen to somebody make a fool of themselves for 3 to 5 minutes than it is for you and me to sit in a deposition for 3 to 5 hours while a hostile lawyer questions you about it. You aren't paid enough for that. You are paid enough to listen to somebody say something silly for 3 to 5 minutes. There are also closed sessions. In closed sessions, I suspect that the public doesn't necessarily believe this. Closed sessions tend to be unbelievably boring. I know that I've had council members who were gadflies in public, and they were public gadflies, sure that they were doing lots of secret business in closed session, and then they get elected to council and they find out that in fact we're spending a whole bunch of time back there talking about whether we take $72,000 or $68,000 as an offering price for a piece of property. They're actually not that interesting. However, that gives me an example of why we have closed sessions. The reason why we have closed sessions is because there are situations, and lots of situations, where the town manager himself or through his staff or the town attorney needs to do something or needs to negotiate about something. And it's a crucial part of your oversight responsibility as an elected official to provide us input on what you would like to see. And that property example is a perfect one. If you held in public a conversation advising Mr. Unrow about what you think you might pay for a piece of property that you were thinking of acquiring, guess what? That's exactly what you're going to get. And it's not good for the public to have that be too public, so to speak. It's important to note, however, you can't make any decisions in a closed session. No decisions can be made. Talk can be had. Lots of talk can be had if you want to. But no actual decision can be made. All actual decisions of council need to be held by a public vote during a public session.
If anything gets out of closed session, is there a consequence for it? What can be done that we got out?
So there are a couple of different approaches to that. State code doesn't provide for any penalties as such. Now, there's going to be obvious penalties that are going to come back to you in that if you happen to be a person who goes and talks about stuff that happened in closed session, the other 4 members of council aren't going to trust you to tell you as much anymore. And that might make you worse at being a councilor. The ultimate sanction, however, is that in the Federal Fourth Circuit Court of Appeals has held that this is a right that every legislative body, and council is a legislative body, inherently has, is the ability to fine its members and otherwise punish them for violations of its rules. And one of those things that very few things that I've ever seen a council or a board of supervisors actually vote to punish somebody for was telling tales out of school out of a closed session. So even that's exceedingly rare. I want to say I've seen it 3 times maybe in my whole career, but it's a thing that actually happens. It's probably the only thing I've ever seen them get angry enough to want to sanction another member for.
Do you have to have that ordinance already on, having been approved before you can do that, or is that on a per case basis?
That is on a per case basis. That issue was in the process of being litigated in Lynchburg when it was resolved last year or the year before. My reading of the court case from the federal court is that it's an inherent ability, that you don't have to have an ordinance in place. However, the penalty's probably got to be proportional. If somebody tells tales out of school from a closed session and council fines them $50,000, I bet you court's going to have some trouble with that. If they fine them $250, I bet you court's going to be okay with that.
It's one government I know of, I don't mention the name or whatever, but when they go into closed session, every time they go in, they sign a confidentiality form.
And I know some bodies that do that and some that don't. I'm certainly open to doing that here, particularly if there starts to be, frankly, if there starts to be a need for it. Sometimes economic development prospects will want that. If we got somebody in here who was going to invest $250 million in something in the town, they might very well ask you to sign an NDA before they went and talked to you about their plans in closed session. And that leads to the other thing of you need to certify every closed session, and you certify two things: only the public business matters lawfully exempted from FOIA, and only the public business matters identified in the motion to convene the closed session were heard, discussed, or considered. And it is a roll call vote, and you are asked if you believe there was a departure from the FOIA rules to state yes or no at that time. And if you say no, you need to state what the violation was. So it's a very serious thing, and you want to pay attention to it both when you're in the closed session and when you're coming out. Enforcement of FOIAs by a citizen lawsuit. I know that some people think that it should be done by, or that it is done by the Commonwealth's attorney. It's not. A citizen to enforce FOIA hires their own lawyer and sues the public body. Normally, what the judge is going to do is, if it's about documents, the judge is going to order you to give up the documents. If it's about a meeting violation or a closed session violation, judges tend to be more creative. An example, for instance, that I saw down in Pittsylvania County once was somebody had a closed session violation, and the judge said that for 6 months they could only hold closed sessions for 2 reasons, and that the attorney for that body needed to report to the judge on what had happened in the closed session in the confidential meeting. Judges tend to be creative about this, and then after 6 months, he was like, all right, well, you've done fine, end the injunction. Closed session things are harder, but judges can get creative about it. Note that if it was willful and knowing, you can face personal fines for a FOIA violation. So if you ask Chuck, Kyla, and me, and we all tell you don't do that, and you go and do it anyway, you might have a problem. If you're acting in good faith and you make a mistake, you're not going to face a personal fine, although a judge may ding you. If we lose a case, then we got to pay the attorney's fees for the person who sued the locality. If we win, then we don't. That's how that works. There is ongoing training and guidance. I'm always available. There is an outfit called the FOIA Advisory Council. It's actually a state agency. Their director is a fellow named Alan Gernhardt. He's very, very capable. He will answer your questions. We do need to have our FOIA officer registered with the FOIA Advisory Council. And like I said, all newly elected and some appointed officials need to take regular courses. That is a pretty surface level look at it. There are literally hundreds of thousands of pages of cases. Couple of other things one other thing to keep particularly close to mind that people have gotten in trouble for a couple of times recently. text messages. Text messages and emails, basically. There should not be a text chain with all 5 of you on it. Period, end of discussion. Because that is going to look like an electronic meeting. No matter what you do about it, it's going to look like an electronic meeting. Just don't bother with it.
I can text each and every one separately.
That's right. You can have a phone call with each of you separately, just fine. You might very well all know how everybody's going to vote on a controversial topic because all of you have called each other and talked one-on-one. But you can't meet beforehand more than 2 of you at a time. Unless you advertise it and hold it as a meeting.
What is the, what if that was more than 2 minutes? What would be the, how would they determine the penalty? What would be the penalty? Say if 2 of us was in a restaurant and the 3rd one came in and sat down and over 2 or 3 beers without a drink, you started to talk about town business. What kind, would you be fined? Would you ask, would you be resign, or who would that be up to?
That would be up to a court, ultimately. Court could scold you, might fine you. I know that one of the issues that you're going to have, which can be difficult, is 3 of you are out. You went to a thing at the Masonic Theater, and you just happen to see each other there, and you go and you're having a beer afterwards, and you're just chatting about life and the universe, and talking about, trying to think of something. You're talking about whatever it is that you might talk about that's not town business. And you're talking about how you think that UVA is going to get crushed even worse this year than usual by Virginia Tech. And I'm a UVA grad, so I can say these things. And somebody comes up to you and they want to talk to the 3 of you about town business. It might be that one of you needs to get up and go take a walk around the block. And so you kind of got to be cognizant of yourself and paying attention to what's going on around you. And sometimes you can say to a person, hold on, this is 3 of us, you're going to make this into a meeting, can we not? Sometimes you're just going to have to say, I'm sorry, I'm going to need to, I think I have a phone call to make. So, it's tough. It's not the easiest thing or the most natural thing, particularly in a small town, but I didn't make the rules. If I had, they'd be a little different.
Thank you very much.
All right, sorry to take up so much of your time with that, but it's important that you understand kind of the basics of it.
One thing that I thought about when you talked about having a quorum at a meeting,
Yeah.
I know we had some people out of town at some training, and they weren't sure if they were going to be back in time for a meeting. So if you have a publicly scheduled meeting and only 2 people are present, can you still have the meeting legally, even though it's less than the quorum, without voting on
Correct.
stuff?
The only actions that can be taken at that meeting, of course, are to get people there and to adjourn. Those are the only things that are in order at a meeting without a quorum.